Okay. Good morning, good morning. Good morning, kings and queens of the land. Good morning, the royals. Good morning, the liberated zones of Africa, Burkina Faso, Niger, and Mali in the Sahel. Good morning, the liberated zone of KZN in South Africa. Good morning. Uh, good morning to uh, everybody, ladies and gentlemen. My name is Mngoni Mkonto. This is the Royal Opinion, where we discuss and analyze politics and social issues. Actually, all issues that affect Black people, we discuss in this show. Today, in discussion, we are talking about the persecution of President Jacob Zuma, the persecution of President Jacob Zuma, uh, the clear persecution of President Zuma by the system. Today, with regard to the contempt of court case against President Zuma, I want to share. Let me share where it started actually, so that we have an understanding.
A lot of exchange, correspondence exchange, and the propaganda machine out there has been quite alive. And I thought it's important that we place certain things on record because I said this on the first day of this commission. And the letters demonstrate that people don't believe our undertaking. I said to the chairperson that the former president established this commission and is willing to cooperate. So all the speculation about
Yes, you did.
is untrue. Mr. Mancha did set out some of the problems that emerged here, the notices that we didn't receive. So I do not want to traverse that ground. The ground I want to traverse starts from the 30th of April because the speculation and some of the misunderstandings emerge from the correspondence starting from that day from the commission. And the most important paragraphs in that letter of the 30th of April this year is that it says in paragraph 1A and B, the former president is being invited here to put his side of the story, to state his side of the story. And the second one says that the commission wishes to ask him a couple of questions. And the second letter then from there, and I want to state this because there's been a misunderstanding about why his attorneys were inquiring. You will recall, Chairperson, that in terms of your rules, the rules of this commission, 3.3 in particular, one of the rights of the witnesses or implicated people is that they make an election when you tell them that you believe they're implicated. They make an election that I've listened to this, I have read the statements, I do not think I am implicated. And they do so at their peril, of course, because they must accept that you may make an inference. And the former president made that election in respect of all. And this was done in careful consideration of whether or not he had been implicated in the two crimes that this commission is about, fraud and corruption. We're not sure about the other one because its elements are not yet established, the one called state capture. So in the second letter, we request the questions. The chairperson will recall that in 3.10, it sets out a number of ways in which he could come here. And we asked for that specific, we made that request. We were not being facetious.
Remember, this is the state capture was for investigating corruption that was done by President Zuma. It was initiated because they said he had a corrupt relationship with the Guptas. Basically, they wanted the state capture commission was set up for President Zuma. So they say it was a state capture. That's why even the name state capture uh, suggest that the state has been captured.
It has a request because, as you will see today, I hand over Mr. Zuma to you, the former president, without knowing what he's going to say. None of us in this room know which names he's going to mention. And we were asking that question because an unfairness has happened in this commission, where people have been blurbing names of people, connecting their own dots about people. And those people have
Let's all mark the register. Let's all mark the register. Thank you very much. Thank you very much, Nkosana. Let's all mark the register. Everybody who is joining, mark the register. Mark the register.
not been able to be noticed, to be given notice in time. And of course, there is some injustice that Mr. Zuma may do today. And that is why we were asking for specificities so that we could prepare him, we could advise him to go to certain people and not mention names of people without you as the commission giving them notice. That was not appreciated by Mr. Pedler or on your behalf, because there was a belief that we were doing a Stalingrad or a Zuma tactic, as it's called. You will see that the other letter, we have an exchange until the 24th of June. Chairperson, the letter that really, I think we must record it for your attention, although it's done on your behalf, but I'm certain that these particular words, because they were difficult for us. It's the letter of the 7th of June. We tell your Mr. Pedler, or the attorney tells him, please, in terms of which rule are we coming? And of course, because he has adopted, or there's a position that this is not genuine, he tells us, he says, this is done in terms of no rules.
This is the white system being clearly arrogant and showing to President Zuma that he can't ask for any legal procedure from this. He requested them to tell him in which rule am I coming to testify in the state capture commission according to your rule. They told him clearly that for you, we are not going to apply any rule. You are coming there just like the rule of the jungle. That's what you are coming to do there. They clearly told him without even trying to do any hiding. They clearly tell President Zuma that you are coming here because we don't want to apply the rules. There's no rule that are going to apply uh, on you. What is going to apply is the law of the jungle. That's what they were telling President Zuma there. I'll take it a little bit back so that you hear.
We tell your Mr. Pedler, or the attorney tells him, please, in terms of which rule are we coming? And of course, because he has adopted, or there's a position that this is not genuine, he tells us, he says, this is done in terms of no rules. And that's one part that is missing out there, is that we are told by a creature of statute, that they are calling a witness in terms of no rules. He says it's a courtesy. We write because we say, this is dangerous. We want to prepare him. Well, the next letter is the letter of the 12th. It explains exactly what I've said to the chairperson. On the 20th, there's another letter. Then on the 24th of June, chairperson, you will see the tone of Mr. Mancho's letter. He does give up because his client has given up. And he says, well, I'll bring him. Chairperson, I'm raising this. That was the last letter. I'm raising that because there's truly a particular, a disturbing attitude that one finds in the letters. And it's an attitude that one does not expect in a legal process like this that is designed to treat each and every witness as a witness who must be put to rigor. And we believe that had we been given an opportunity to prepare Mr. Zuma, to advise him about people's names that he may mention, that he can't do so without those people being given notice, this process today would be much better. And so I'm going to hand him over to you, Chairperson. I'm making these things because he had a request, which is to address you, to put his side of the story as he sees it, to connect his own dots. And that's what he's about to do.
No, that's fine. We asked him to come and give his side of the story, and he will be allowed to do that.
Thank you, Chair.
Thank you. Mr. Pretorius?
Just very briefly, we haven't had notice of any substantive application, and I don't believe there is a substantive application before you, Chair. But just to clarify on a number of issues.
Giving people notice. The problem is this attitude exactly of this commission, is that people bring their views outside and treat certain witnesses as sweethearts and others as accused. I am saying it's important that everybody who comes here gets the same rigor and the same questioning. People must not bring their own ideas out there. And I think Mr. Pretorius is doing exactly that. I was articulating to you, Chairperson, the dangers that we saw, and that is why we kept asking. And I don't think I was inviting his condescension, because he didn't understand what I was saying. He truly did not. And this is the problem we've been speaking from himself. And those that he's going to mention are going to be treated fairly because they don't know he's about to out them. Thank you, Chair.
Well, before you sit down, Mr. Skakane, as you say, the letters from the acting secretary of the commission were written on my behalf.
Yes, Chair.
Actually, I fully approved each one of them, and so I just want to make that clear that the words in the letters can be taken to be my words.
The words which is talking about, which can be taken as his words, the letter was saying, the question was, in which rule are you calling the president to come and testify? And the answer was, in terms of no rules. We are calling him in terms of no rules. There is no rules that we are going to specifically apply on him. We will use the law of the jungle. So this is the Chief Justice owning up to that, saying that all of those words in the letters can be taken as his words to President Zuma, that is calling him to this commission in terms of no rule. So if somebody calls you into a commission in terms of no rules, which has to use rules, would you really trust that that person is going to be fair or on you? or when they tell you straight that they are not going to apply the normal rules that are supposed to be applied according to the commission. So it was him owning up that this is not accordance to any rule. So what did President Zuma say in the State Capture Commission? President Zuma has been persecuted. Remember, you cannot go, you cannot be arrested for not going to a commission of inquiry. For refusing to go to a commission of inquiry, you cannot be arrested according to the law. They have thrown away they've taken the law out in the pursuit of the persecution of President Zuma. President Zuma, they could not, it was not supposed to happen that President Zuma be arrested or be persecuted um, according to the law. You cannot arrest somebody for refusing to go to the commission. The former president, P.W. Botha, has refused to go to the Truth and Reconciliation Commission. The former president was, uh, uh, he ordered for killing of a lot of black people, but he refused to go and testify to the Truth and Reconciliation Commission. Nothing happened to him. President Zuma did not do anything wrong. They call him in terms of no rules into the State Capture Commission. And calling him in terms of no rules into the State Capture Commission, wanting him to answer questions that range, because no rules apply, ranges, God knows from where to where. So I wanted.
But we accept that
I've been given every other name, and I'd never responded to those issues. Firstly, because I believe it is important that we all respect one another, that we must say things we know about other people, not just tell things that we cannot prove. This has been my nature as I grew up, and I joined the ANC in my early age. In addition to the teachings from my own homestead and my parents, I also got taught in the ANC to behave in a particular way. And I have paid for my activities in the ANC, including going to prison, serving a term of 10 years. At some point, I had to leave my country to go out.
President Zuma was arrested for planning to overthrow the apartheid government, and he was jailed for 10 years in Robben Island for planning to overthrow the apartheid government. President Zuma has been a struggle, has been a fighter against the white system. So he was charged of treason of trying to overthrow the apartheid government, and then they found him guilty and sentenced him to 10 years, and he served this sentence in Robben Island.
And in the process, the ANC gave me different responsibilities at all material times
Let's click the
that I
like
have
button
been
and subscribe. Let's click the like
active
button and
and
subscribe
participating. Then
if you
finding
are coming for the
myself
first time.
finally in the leadership of the ANC.
Mark the register. Let me know who you are
The reason
and
why
where you come from.
I'm starting here, Chair, is because when this commission was proposed or a recommendation was made that I should establish a commission by the public protector, the previous one, there were certain issues that I was not happy the manner in which they were handled. And of course, the commission was to deal with an important point. But as I will indicate, part of the reason why I'm here, that's the background I'm going to deal with, why I find myself sitting here today, and where it comes from. Particularly because this commission, from my understanding, was really created to have me coming here. And perhaps
Many South Africans were still unaware, and we were all, most South Africans were persecuting President Zuma at this stage. He's saying the commission is actually established for him, especially for him to come there. And at the end of the day, everybody have seen that it was
to
established for him.
find things on me. I will deal with how it was conceived and therefore made the commission as to what it is. Because the ANC gave me tasks, perhaps I had to know things that other people might not have known. And the question is, how would I handle those? And I was taught how to handle them. That is why, in the background that I'm going to give, I will strengthen this point I'm making. Sorry. Mkhuhlane uyalo ukuthi ngikhulume.
That was Zulu for saying the flu is preventing him from speaking.
There has been a drive to remove me from the scene. A wish that I should disappear. And I will explain where it comes from. why perhaps it is important that I deal with in this commission. And it arises out of perhaps my work in the ANC, and also because of who I am. This conspiracy against me has been stretched at all material times when there are things to be done or said. It has come in different forms, and that's why there are even people who say I've got a way of trying to dodge things in one form or the other. And I'm going to connect the dots over a decade that talk to this point and talk to why I'm here. As you know, in 1990, the ANC was unbanned. And I was one of those who was sent ahead of everyone to make contact with the then government to study the process of finding a solution in this country. People referred to it as talks about talks. I then became part of the negotiating team, and we finally reached a point where those who were in prison were out, those who were in exile in his organization. Whom we want to nurture, that they grow within the structures of the ANC to a point that it have to lead the ANC. To ask those who would be receiving the question and giving an answer, they should not know that this question comes from me, because we had people in the intelligence, had a lot of networkings and networks, as well as people dealing with different things. So we sent the question. After a brief period, the answer came back. Was the reason we wanted to assassinate the Zuma's character was because he has a lot of information that he holds. Among that type of information, as a chief of intelligence, there are spies that are infiltrated by us in his organization. Whom we want to nurture, that they grow within the structures of the ANC to a point that it have to lead the ANC. Now, Zuma has information about these. We don't know when will he use this information to stop that process, that plan of theirs. And therefore, they took a decision that Zuma must be removed from decision-making structures of the ANC.
They have been afraid that President Zuma all along, the white system have been afraid that President Zuma knows the plan that they have about the ANC, and they were worried that when they try to implement the plan, because President Zuma is well aware of the plan, is going to make sure that they don't succeed. So they wanted him to be removed, and they wanted the spies to lead the ANC. That's what they wanted to do, and that's why they set up this commission. This commission was to bury President Zuma alive. It was to finish him. So this is what is trying to explain in this conspiracy against President.
And that's why the character assassination began. That's the beginning of the process that has put me where I am today. And I thought it is important to go through this. Whatever else will be the end of your process, but at least some truth should be known. We handled this at a very, very delicate intelligence. When I was going to be a 1990 of the ANC, it was a consultative conference, not elective conference. But these three organizations thought that it was an elective conference. That's why they were engaging in this plan and this conspiracy.
So the organization that is talking about is the American intelligence, the CIA and the British intelligence. Those are the people who've been planning to remove President Zuma from the ANC, because that's why President Zuma, when he started the MK party, he said, I wanted to rescue the ANC. And nobody understood what he's talking about, because he knew the hidden plan that the white people had about the ANC. He knew about the GNU. He knew about the end of the ANC since the 90s. He knew about how the ANC will end since the 90s. So President Zuma was the only stumbling block in the ANC who was going to stop these people, because he knew the plan. So they wanted to eliminate him at all cost, at whatever cost. That's why they brought him to this commission. I want us to move on now to the judgment, to the Khampempe judgment.
Down judgment in an application brought by the Secretary for the Judicial Commission of Inquiry into allegations of state capture, corruption and fraud in the public sector, including organs of state, being the applicant, for an order declaring former President Jacob Gedleyihlekisa Zuma being the first respondent to be in contempt of court for failing to comply with an order made by the
Zondo made an application to the Constitutional Court that they want them to declare that President Zuma is guilty of contempt of court. There's a difference between being declared and being found guilty. So he was not found guilty, he was declared guilty. The difference between being declared, there has never been any criminal process that was followed to find President Zuma guilty of any crime. He was just declared guilty without a process. No process was followed to find him guilty. The Constitutional Court, Zondo requested the Constitutional Court when he was in the commission as the deputy judge, what we call, he requested that this thing, as the chief justice, he requested that the commission must declare that President Zuma is guilty of contempt of court. It was his request to the Constitutional Court. He basically requested, and he even sentenced President Zuma. He requested the Constitutional Court to declare President Zuma guilty of contempt of court, and also he requested the Constitutional Court to sentence um President Zuma without any procedure to a period of 2 years. He recommended 24 months. That President Zuma should be sentenced for 24 months. It was Zondo who recommended all of this. This is the judgment now is ended.
Constitutional Court. In December 2020, in the matter of Secretary of the Judicial Commission of Inquiry into allegations of state capture, corruption and fraud in the public sector, including organs of state versus Zuma, hereafter referred to as CCT 295/20, the applicant approached the Constitutional Court on an urgent basis for an order that would compel Mr. Zuma's cooperation with the Commission's investigations. On 28 January 2021, the Constitutional Court handed down judgment ordering Mr. Zuma to attend the Commission and give evidence before it.
Remember, that order was illegal. The reason President Zuma did not follow that order is because it was just an illegal order. You cannot be ordered to go and testify in a state capture commission by the court. You cannot be ordered. It's illegal for them to do that. You have an option to agree or to refuse to go and testify according to the law. P.W. Botha, who's killed a lot of black people in South Africa, has refused to go and testify in the Truth and Reconciliation Commission, and nothing happened to him. No judgment was handed on him for refusing to go and testify, even though he eliminated or alienated or murdered or massacred a lot of black South Africans, a lot of black people. We can mention it straight like that. President Zuma, not guilty of any corruption, not even accused of corruption. You see, in this judgment, Judge Khampempe intentionally talks about corruption, but in this judgment, it's not about corruption, it's about contempt of court, of which he never went to any court. He only went to the commission. He did not go to any court. So we're discussing the persecution, the clear persecution of President Zuma by the system. Let's expose them.
The judgment and order were served on Mr. Zuma, who responded by releasing a public statement in which he alleged that the Commission and the Constitutional Court were politicizing the law to his detriment. From 15 to 19 February 2021, Mr. Zuma did not attend the Commission as ordered. Accordingly, the chairperson of the Commission announced that it would launch contempt of court proceedings. On the same day, Mr. Zuma published another statement in which he leveled serious criticisms against the judiciary and confirmed that he would neither obey the Constitutional Court's order nor cooperate with the Commission in any respect. The applicant proceeded to approach the Constitutional Court for direct access on an urgent basis, submitting that a court that grants an order retains jurisdiction to ensure its compliance. The applicant submitted that, considering Mr. Zuma's former and current political position in South Africa, his conduct constituted a particularly reprehensible affront on the integrity of the rule of law and the Constitution. Accordingly, that it was apposite for the Constitutional Court, as the guardian of the Constitution, to respond to Mr. Zuma's efforts to undermine the judicial process.
the judicial, they are responding to him, not because he did any crime. This is in response to him criticizing them. Uh, the Constitutional Court responds. This is their response to President Zuma when he criticized them. This has got nothing to do with the law. It's only their response when President Zuma criticized them, that they are not applying any law. They are using the law of the jungle, because you cannot force anyone to go into a state capture commission using the law, because the law does not allow you to force people to do so. Peter Botha, again, did not go to the state. He blatantly refused and said it was a fallacy. Nothing was happening there, and it was true.
On urgency, the applicant submitted that the matter warranted swift intervention on the basis that Mr. Zuma's conduct poses a grave threat to the administration of justice and the rule of law. Mr. Zuma is an influential political figure who wields significant power to inspire others to defy courts. The public and forceful nature of Mr. Zuma's defiance compounds the risk posed to the rule of law, and Mr. Zuma's contempt persists unabated. It was the applicant's case that Mr. Zuma is guilty of the crime of contempt of court. It submitted that
The applicant, who is Zondo, says Zuma is guilty. This is before any court can make any judgment. Zondo said President Zuma is guilty. So that's what the judge is saying here, that Zondo has said President Zuma is guilty. So let's hear what they respond to.
can be no doubt that Mr. Zuma had knowledge of
Without trial, without going to any court, without finding him in any court guilty of anything, he declares, the applicant, which is Zondo, declares that Zuma is guilty. So he writes to the court, to the constitutional court, that please declare him guilty because I say he is guilty. Let's continue.
order in CCT 295/20. His non-compliance with the court order was undeniable because he failed to attend and give evidence before the commission, and he failed to present any evidence to avoid the conclusion that his non-compliance was willful and mala fide. The applicant further submitted that
He's the first person to be charged for refusing to go to a commission. He's the first person. He was not even charged. He was just declared guilty, because there's a difference between, if you are charged, then you will go to the criminal route. So there was no criminal procedure that was applied on President Zuma. It was just declared and straight sent. It's like monopoly, sent straight to jail. No fine, nothing. Send him straight to jail. That's what was happening here. The persecution of President Jacob Zuma, the persecution of President.
in ostensibly defending his contempt, Mr. Zuma conducted a politically motivated smear campaign of the Constitutional Court, the Commission, and the judiciary. According to the applicant, his tactics, coupled with his unique position, should count as aggravating factors in the determination of an appropriate sanction. Ultimately, the applicant sought a punitive sanction in the form of an unsuspended order of imprisonment for a period of 2 years on the basis that only a punitive order is appropriate, given that this is a unique and extreme case of contempt of court for which there is no meaningful precedent. Mr. Zuma did not oppose this application, nor did he file any submissions. The Helen Suzman Foundation.
So what happened is Zondo wrote a letter to the court to say Zuma is guilty. Please find him guilty of contempt of court. without President Zuma having arrested and went to any court. He requested that the constitutional court should declare him that irrespective of this fact that President Zuma is guilty, declaration of President Zuma as guilty.
Applied to be admitted as amicus curiae. Its main submission was that an appropriate sanction must be capable of vindicating the dignity of the court, as well as compelling compliance with the impugned court order. It submitted that the appropriate sanction may be an order for Mr. Zuma's committal for a minimum compulsory period, coupled with either of the following: an order which would curtail further imprisonment where Mr. Zuma voluntarily testifies before the commission, or an order directing the sheriff of the High Court to escort him to the commission to testify following a mandatory period of imprisonment. The Constitutional Court is satisfied that the Helen Suzman Foundation met the requirements to be admitted as amicus curiae. Its submissions are relevant and are of assistance, particularly to the question of
Amicus Curiae, whatever it is, amicus curiae. It's only a term that is used to confuse people, to be able to admit evidence that does not exist, calling them in other foreign languages that confuse people. They should use language, English language, or use local language. I'm Korean. I did not even bother to understand that nonsense, because there's no need for us to understand such a nonsense. We need to talk the right kind of language for people to understand. Why do you talk a language that is confusing for people? So it's only for confusing people that President Zuma is guilty of amicus curiae or what. It's nonsense.
sanction. It is therefore admitted. In this matter, two judgments have been penned. The majority penned by myself, with Matlanga J, Majid J, Mhlantla J, Bile AJ, Tlaletsi AJ, and Shikri J concurring, and a dissent penned by Theron J, with Jafta J concurring. I shall begin with the findings of the majority of the Constitutional Court. Let me begin by saying this. It is the lofty and lonely work of the judiciary, impervious to public commentary and political rhetoric, to uphold, protect, and apply the Constitution and the law at any and all cost. The corollary duty borne by all members of South African society, lawyers, lay people, and politicians alike, is to respect and abide by the law and court orders
At all cost, even at the death of people, at all cost, they must do what they want to do, even if it means other people will die. It does not matter. At all cost, they must defend this system, this white constitution and the white system.
issued in terms of it, because unlike other arms of the state, courts rely solely on the trust and confidence of the people to carry out their constitutionally mandated function. The matter before us has arisen because these important duties have been called into question, and the strength of the judiciary is being tested. I penned and now hand down this judgment in response to the precarious position in which the Constitutional Court finds itself on account of a series of direct assaults, as well as calculated and insidious efforts launched by Mr. Zuma to corrode its legitimacy. After all, it is the Constitution alone that we owe our allegiance. According
So they penned this judgment not because President Zuma is guilty of anything, to defend themselves against his suggestion that they are a bias. So they want to defend themselves. The reason they pen this is clear. She's clearly stating that she pens the judgment to defend herself from the utterances of President Zuma in public, not because he is guilty of anything, because he's never been found guilty of anything, of breaking any law. So here, Zondo have requested that exactly that he be declared guilty. Let's hear uh, what. Let's continue to hear what.
Accordingly, we are here because we have no choice but to respond as firmly as circumstances warrant when we find our ability to uphold it besieged. This matter engages the Constitutional Court's jurisdiction. These being contempt proceedings, the court's power to protect its own processes in terms of Section 173 of the Constitution is implicated.
Remember, the Constitutional Court cannot be a court of the first instance and the court of the last instance. And the Constitutional Court cannot be involved in a criminal procedure. The Constitutional Court has to be involved where uh, the issues has to do with the law. We had to do with the Constitution. The Constitutional Court should be involved in cases where it has to do with human rights. So the Constitutional Court, it was not their jurisdiction to hear this case. They were supposed to refer this case to the criminal court. If they say it's contempt of court, the Constitutional Court was supposed to refer Zondo. Zondo knows exactly that he was supposed to take the case to the criminal court if there's any case against President Zuma. Because there was no case against President Zuma, there was nothing to take to the criminal court because they wouldn't win anything. This was just a persecution of President Zuma by the system. So we need to clearly hear the persecution of President Zuma.
Furthermore, when the constitutional safeguards of the judiciary are undermined so egregiously, as in this case, Section 173 empowers the court to respond swiftly and effectively in its own interest and in the interest of justice. This matter also concerns the protection of the authority of the judiciary.
So the court has its own interest. What is the court? Why should the court has its own interest instead of the interest of the community? Because the court is set up for the interest of community. Why should the court has its personal interest? So here they are responding because the court says it has interest on the issue.
Judiciary to carry out its constitutional functions vested in it by Section 165 of the Constitution, which functions are threatened by acts of contempt of court. Thus, the issues at the heart of this matter are irrefutably constitutional issues. On the question of direct access and agency, the Constitutional Court holds that this matter is so evidently extraordinary that a departure from ordinary procedures is warranted and is in the interest of justice.
They decided to depart from the normal procedures. They say the Constitutional Court sees it necessary or warranted to depart from the law. That's what they are saying. They are not going to follow the law. They will act according to how they feel or how they want. They are not going to follow the law. It was just a persecution, a clear persecution. The judge even mentioning that if we have to follow the law, we won't win. So here we are not following the law. We are persecuting him outside of the law. That is the judge saying. It's not me. Let me just reverse it a little bit. Departure from the procedure.
Hence, the protection of the authority of the judiciary to carry out its constitutional functions vested in it by Section 165 of the Constitution, which functions are threatened by acts of contempt of court. Thus, the issues at the heart of this matter are irrefutably constitutional issues. On the question of direct access and agency, the Constitutional Court holds that this matter is so evidently extraordinary that a departure from ordinary procedures is warranted and is in the interest of justice. Never before has the authority and legitimacy of the Constitutional Court been subjected to the kinds of attacks that Mr. Zuma has elected to launch against it and its members.
President Zuma has been exposing that the system is unfair. So here the judge is mentioning that it has never happened that the judicial has been challenged like President Zuma is challenging them. Because he's not guilty of anything, he has to challenge them. So here they are just purely responding on his utterances in the public. They are not responding to him as a criminal because he's never found guilty of any criminal offense. It was just a witch hunt. It's a witch hunt even now. They are still persecuting him even today. For the past 30 years or so, President Zuma has been in and out of courts, being persecuted for no reason.
Never before has the judicial process been so threatened. It goes without saying that neither the public's vested interest nor the ends of justice would be served if we decline to exercise our special authority as the guardian of the Constitution, and if this matter were to be required to traverse the ordinary and lengthy appeals process. Furthermore, the vigor with which Mr. Zuma is peddling his disdain of the Constitutional Court.
So they decided to break the law, and breaking the law in many, many respects. They broke the law. First, they break the law instead of allowing President Zuma to go to the criminal court. That's what they have to do. They break the law, they accept the case. So instead of again breaking another law, instead of allowing President Zuma to defend himself in the court of law, they decide to break the law and divert from the normal procedures. Instead of allowing President Zuma to appeal the case, they break the law again and be the court of the first and the last instance. Because the law says everybody has got a right to appeal if found guilty of any crime. So President Zuma was declared guilty of crimes he did not do and was not allowed to appeal those crimes. He was just sent straight to prison, just like they are playing Monopoly. Click the like button and subscribe. This is the Royal Opinion. My name is Mngoni Mkonto. Thank you very much, Nkosana Fulani, for joining, and thank you, Cynthia, for joining. Queen Cynthia there. Thank you very much. Let's go on.
And the judicial process carries the risk that he will inspire others to similarly defy court orders. It cannot be gainsaid that the longer that Mr. Zuma's recalcitrance is allowed to sit in the light and heat of the day, so the threat faced by the rule of law and the administration of justice curdles. Because of these exceptional circumstances, it is in the interest of justice to grant direct access and to do so on an urgent basis. The Constitutional Court holds that there can be no doubt that Mr. Zuma is in contempt of court. A judgment and order was handed down in favor of the applicant in CCT 295/20. Mr. Zuma was served with the order, and it is impossible to conclude anything other than that he was unequivocally aware of exactly what it required of him. Mr. Zuma failed to appear and give evidence before the Commission on the date so ordered.
The order that he refused to abide by is the order that said he should be forced to go to the State Capture Commission because it was an illegal order in the first place. Nobody should be forced to go to any state capture commission or any commission. If they don't want to go there, they don't want to go there. So it was first, even that order, it was an illegal order declared by Zondo as well. Now again, because they refused to implement that illegal order, now they go on to implement.
Gave it in accordance with the chairperson's directive. Mr. Zuma is therefore in blatant violation of the court order made in CCT 295/20. To his peril, Mr. Zuma has not presented any evidence to establish a reasonable doubt as to whether his disobedience of the order was willful and mala fide, and the extent to which Mr. Zuma has attempted to justify his defiance through public statements is of no relevance. The statements were not formally pleaded, so fall to be disregarded. The Constitutional Court can do nothing but conclude that Mr. Zuma is guilty of the crime of contempt of court. The majority.
So they conclude, according to the request of Judge Zondo, that President Zuma should be declared guilty of contempt of court, even though he did not go to any court and he did not have any order, legal order against him. All of these things were illegally posed on him. So the judge declares him guilty of contempt of court, the persecution of President Zuma. The persecution of President Zuma. Let me read the statement. When Peter Botha refused to go to when he refused to go to the what we call to the TRC, Truth and Reconciliation Commission. Nothing happened to Peter Botha. Let me read the statement. But because it's President Zuma now, President Zuma must be found guilty. Former President Peter Botha declares that he would never testify before the Truth and Reconciliation Commission. He also stated that he would never apologize for apartheid and called the TRC the fierce, unforgiving assault on the Afrikaner by the African National Congress, led government. Botha, who became Prime Minister of the Republic of South Africa in 1978, later as president from 1984 to 1989, made his comments in written statement issued after a private meeting with the chairperson of the commission, Archbishop Desmond Tutu. The meeting was arranged after a series of witnesses had told the commission that Botha had personally ordered state violence during his tenure. Botha guilty of state ordering violence on black people. Botha claimed that he had never been associated with blatant murder, but conceded that there might have been situation that his authority could have been stretched a little bit. In his 10-page statement, Botha believed that the past and moving on. What is that? Okay. His statement was a clear contradiction of the TRC, what the TRC stood for. That's where my reading ends. President Zuma being persecuted for refusing to go to the State Capture Commission because Judge Zondo decided to persecute him. Requested Judge Zondo to recuse himself, but Judge Zondo, instead of recusing himself, he wrote a letter to the Constitutional Court to tell them that they must find President Zuma guilty of contempt of court because he requested him to recuse himself, and he does not want to recuse himself. And because he represents the system, there's no problem. He is free to act like that, and there's no problem. Judge declaring that President Zuma is guilty and that they will find him guilty too. Instead of let's remember they say 24 months. He recommended 24 months, and there's a reason why. Because in law, now we know at the end of the day that they wanted him to be guilty so that he cannot be able to go to parliament. So they were desperately preparing because they knew that President Zuma is going to start a political organization, and they did not want him to qualify to be able to start a political organization. So they wanted him to be guilty of something. uh, and qualify according to the constitution for a particular section. So the system was like preparing for what they wanted to do about President Zuma's
Emphasizes
election.
that it cannot be gainsaid that orders of court bind all to whom they apply. This, in addition to typifying common sense, the Constitution itself enjoins in terms of Section 165, subsection 5. This is because the constitutional right of access to courts would be rendered meaningless unless orders are capable of being enforced by those in whose favor they are made. It is also noteworthy that contempt of court is not an issue between the parties, but is an issue between the court and the contemptuous party. Thus, although the harm caused through contempt of court to successful litigants like the applicant is by no means unimportant, the overall damage caused to society by conduct that
The contempt of court, if you are found guilty of contempt of court, there's a lot of laws that they've broken here. If you are found guilty of contempt of court, the sentence should have been um 3 months, should have been 3 months imprisonment or a fine. So because they wanted the sentence to fit a particular character, it had to be 18 months in prison, because they wanted it to be 15 months to qualify for him to qualify for that section 25 of the IEC. So they were preparing for that. That's why President Zuma was persecuted in this way. Uh, while he was not guilty of any crime, but persecuted in this way for the sake of the section 25, where he was excluded to go to parliament or to lead the MK party.
Poses the risk of rendering the judiciary ineffective and eventually powerless is at the very heart of why our law forbids this conduct. Suffice it to say that the mischief the Constitutional Court has been called upon to address is not that Mr. Zuma failed to comply with the summons and directive issued by the Commission, but rather that he failed to comply with the order of the Constitutional Court. Following from the finding that Mr. Zuma is in contempt of court, the crisp question with which the Constitutional Court is seized is the appropriate sanction. A sanction for contempt of court can take the form of suspended committal, otherwise known as a coercive sanction, or unsuspended committal, which is a punitive sanction. The purposes of each differ, made primarily to ensure the effectiveness of the original order. A coercive sanction gives the respondent the opportunity to avoid imprisonment by desisting from the offensive conduct and complying with the original order. A coercive order only incidentally vindicates the authority of the court that has been disobeyed. Conversely, in terms of a punitive order, a sentence of imprisonment cannot be avoided by any attempt to comply with the original order. The sentence is related both to the seriousness of the default and the contumacy of the respondent, and the order is influenced by the need to set an example and assert the authority of the court.
So they did not sentence him to 2 years because he was guilty of anything. They wanted just to assert their authority for him, for President Zuma to respect them. They wanted him to respect them. So he was sentenced. That's why they say, let me just take it a little bit back so that you can hear clearly why they sentenced him.
The sentence is related both to the seriousness of the default and the contumacy of the respondent, and the order is influenced by the need to set an example and assert the authority of the court.
The need to set an example and assert the authority of the court, not because he's guilty of anything. They just want to set an example that when you don't want to comply with the white system, this is what we're going to do to you. We want to lynch you publicly so that people can see your public lynching, that you are not agreeing with the white system. The white system wants to implement the colonial rule as it is. So if you are anything doing something else other than allowing them to implement their colonial rule over black people, they will assert their authority and prove to you how powerful they are. This is what this is what they say in their judgment. It's not me. It's exactly what they say in their judgment.
Bearing this in mind, the majority holds that a coercive order which uses the threat of imprisonment to compliance would be both futile and inappropriate in these circumstances. Of course, society, holds an interest in Mr. Zuma testifying before the Commission, given that it was under his presidency that the alleged corruption and malfeasance under the investigation by the Commission took place. Nevertheless, notwithstanding the importance of the work of the Commission, the Constitutional Court cannot be so naive as to hope for his compliance with the order made in CCT 295/20. Mr. Zuma has repeatedly reiterated that he would rather be imprisoned.
So they assume that even if they apply the law normally, they don't believe that President Zuma is going to comply with the law. So that is why they decided not to use the correct law to be applied on President Zuma, which was he was supposed to either be sentenced to 3 years or be uh, what we call pay a fine. He was supposed to pay a fine if, let's say, he was guilty of contempt of court, and the amount that he's supposed to pay is very little according to the law. Because it's in British pound, it's a very old law. We're still using apartheid and colonial laws in South Africa, so it's a very old law, which says contempt of court, the sentencing in the contempt of court should be a fine or a 3-month sentence. So the Constitutional Court decided this will not be asserting their authority. This sentence, which is recommended by the law, will not assert their authority. So they decided to move away from the law in order to assert their authority and punish President Zuma, to prove to anybody else or any black people who want to divert uh, from the system, to prove to them that they will not be able to succeed against this white system. They will be lynched publicly.
Than cooperate with the Commission or comply with the order made in CCT 295/20. Accordingly, it defies logic to believe that a suspended sentence, which affords Mr. Zuma one final opportunity to submit to the authority of the Commission, would have any effect other than to prolong his defiance and to signal dangerously that impunity is to be enjoyed by those who defy court orders. An additional deficiency with a coercive order is that the punitive effect of it would...
So they give justification of why they decide to break the law. Like as if they are allowed to break the law as and when they want. They are justifying that we actually we are now breaking the law because we don't believe President Zuma will as well follow the law if we want him to follow the law. So we decide now, because he's been talking somewhere else, and we heard him through the media talking. So we're now breaking the law in order to punish him, to show him not necessarily that he has done anything, but we want to assert our authority, the authority of the white system.
Only operate upon future non-compliance. In other words, it wields no punitive power in respect of Mr. Zuma's contemptuous conduct, already so worthy of rebuke. The majority finds that it is impossible to see...
Worth of rebuke, I don't know by whom. Like President Zuma is worth of rebuke. Who should rebuke President Zuma for what? For talking that the Constitutional Court is unfair on him, or for what? I don't understand. They want to rebuke him. This is a way they're rebuking him by punishing
see how
him
a coercive order
outside of
could achieve any of the purposes of contempt proceedings. Neither the honor of the Constitutional Court nor the public interest in Mr. Zuma testifying before the Commission would be vindicated through a coercive order. In fact, the public has an equally important, if not more acute, interest in a functioning judiciary than in Mr. Zuma testifying before the Commission.
They say there's no need for him to testify in the commission. It's only for them. What is important it's for them to exercise their own authority on President Zuma. Them exercising their authority on President Zuma is more important than President Zuma going to testify in the State Capture Commission. I think I should end it here. This will be part one of the Zuma persecution. We will continue with the Zuma persecution next time because there's still a lot of areas to cover about the persecution of President uh, Jacob Gedleyihlekisa Zuma. Thank you very much for from everybody who is joined. Click the like button and subscribe if you are coming here for the first time. My name is Mngoni Mkonto. We were discussing the persecution of President Jacob Gedleyihlekisa Zuma by the Roman Dutch law. Thank you very much, everybody. I think this is a very long video.